Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click that notification bell so you can be updated every time we upload new content. Question number 1. Dirk is on trial for the brutal murder of Villas. Dirk's first witness, Wesley, testified that in her opinion, Dirk is a peaceful and non-violent person. The prosecution does not cross-examine Wesley, who is then excused from further attendance. Which one of the following is inadmissible during the prosecution's rebuttal? A. Testimony by Wesley's former employer that Wesley submitted a series of false expense vouchers 2 years ago. B. Testimony by a police officer that Dirk has a long-standing reputation in the community as having a violent temper. C. Testimony by a neighbor that Wesley has a long-standing reputation in the community as an untruthful person. Or D. Testimony by Dirk's former cellmate that he overheard Wesley offer to provide favorable testimony if Dirk would pay her $5,000. Take 10 seconds and choose the best answer. If you chose option A, you'd be correct. Testimony by Wesley's former employer that Wesley submitted a series of false expense vouchers 2 years ago. The rule for character evidence in a criminal case is that no character evidence is admissible during the prosecution's case in chief. The prosecution can only rebut character evidence introduced by the defendant first, and the prosecution can do so by offering pertinent character evidence. Impeachment by non-conviction misconduct that bears on truthfulness is permissible, but this method of impeachment is only available on cross-examination of the witness. Impeachment by reputation or opinion evidence regarding the truthfulness of witness is permitted on either cross-examination or extrinsic evidence. Lastly, impeachment by evidence of bias, interest, or motive is permitted on either cross-examination or extrinsic evidence. In this case, Dirk, who is on trial for the murder of Villas, introduced character evidence that he is a peaceful and non-violent person. The prosecution can rebut by offering pertinent character evidence, such as that Dirk is not a peaceful or non-violent person. So B is clearly admissible. Furthermore, C is admissible because it is impeachment by reputation or opinion evidence regarding the truthfulness of Wesley. Lastly, D is admissible because it is impeachment by evidence of bias, interest, or motive. Answer choice A, however, would not be admissible because it would be impeachment by non-conviction misconduct that bears on truthfulness, which is only available on cross-examination of Wesley. Since Wesley was not cross-examined by the prosecution, this type of impeachment evidence would be impermissible. Question number 2. In his employment, Grinder operates a grinding wheel. To protect his eyes, he wears glasses sold under the trade name Safety Glasses, manufactured by Glasgow. The glasses were sold with a warning label stating that they would protect only against small flying objects. One day, the grinding wheel grinder was using a disintegrated product, and fragments of the stone wheel were thrown off with great force. One large fragment hit Grinder, knocking his safety glasses up onto his forehead. Another fragment then hit and injured his eye. Grinder brought an action against Glasgow for the injury to his eye. The jurisdiction adheres to the traditional common law rule pertaining to contributory negligence. In this action, will Grinder prevail? A. Yes, because the safety glasses were defective and that they did not protect him from the disintegrating wheel. B. Yes, because the glasses were sold under the trade name Safety Glasses. C. No, because the glasses were not designed or sold for protection against the kind of hazard Grinder encountered. Or D, no, if Grinder will be compensated under the workers' compensation law. Take 10 seconds. If you chose option C, you'd be correct. No, because the glasses were not designed or sold for protection against the kind of hazard that Grinder encountered. Under the traditional common law contributory negligence doctrine, the plaintiff is completely barred from recovery if the plaintiff was negligent. Here, Grinder was using glasses sold with a warning label. That warning label stated that they would only protect him against small flying objects. The glasses were not designed for protection against large fragments of a grinding wheel, so the grinder was negligent in ignoring the warning label and using the glasses with the grinding wheel. The facts state the jurisdiction adheres to contributory negligence, so grinder's negligence will serve as a complete bar from recovery against Glasgow. Therefore, grinder will not prevail because the glasses were not designed or sold for protection against the kind of hazard that grinder encountered. Question number 3. Deeb was charged with stealing furs from a van. At trial, Wallace testified she saw Deeb take the furs. The jurisdiction in which Deeb is being tried does not allow in evidence lie detector results. On cross-examination by Deeb's attorney, Wallace was asked, "The light was too dim to identify Deeb, wasn't it?" She responded, "I'm sure enough that it was Deeb that I passed the lie detector test administered by the police." Deeb's attorney immediately objects and moves to strike. The court should A. Grant the motion because the question was leading, B. Grant the motion because the probative value of the unresponsive testimony is substantially outweighed by the danger of unfair prejudice, C. Deny the motion because it is proper rehabilitation of an impeached witness, or D. Deny the motion because Deeb's attorney opened the door by asking the question. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. Grant the motion because the probative value of the unresponsive testimony is substantially outweighed by the danger of unfair prejudice. The answer is unresponsive if it goes beyond the question asked of the witness. A motion to strike must be made immediately after a witness's response and can only be made when the original question did not obviously contemplate an objectionable response. In this case, during cross-examination, Deeb's attorney asked Wallace, "The light was too dim to identify Deeb, wasn't it?" To which Wallace responded, "I'm sure enough that it was Deeb that I passed the lie detector test administered by the police." This response was clearly unresponsive as it added something in addition to the yes-no question by Deeb's attorney that did not respond to the specific question and introduced the results of a lie detector test that are inadmissible in the jurisdiction. Deeb's attorney immediately objected and moved to strike, so the trial court should in fact grant that motion. Question number 4. Which of the following fact patterns most clearly suggests an implied in fact contract? A. A county tax assessor mistakenly bills Algernon for taxes on Bathsheba's property, which Algernon in good faith pays. B. Medic, a physician, treated Ryder without Ryder's knowledge or consent while Ryder was unconscious as a result of a fall from his horse. C. Asphalt, thinking that he was paving customer's driveway for which Asphalt had an express contract, mistakenly paid Nabor's driveway while Nabor looked on without saying anything or raising any objection. Or D. At her mother's request, Iris, an accountant, filled out and filed her mother's easy income tax form. Take 10 seconds. Choose the best answer. If you chose option C, you'd be correct. Asphalt, thinking that he was paving customer's driveway for which Asphalt had an express contract, mistakenly paved Nabor's driveway while Nabor looked on without saying anything or raising any objection. An implied in fact contract is a valid contract formed under a set of facts that imply an intent to contract. In C, Asphalt mistakenly paved Nabor's driveway while Nabor looked on without saying or raising any objection. An intent to contract was implied by Asphalt starting to pave Nabor's driveway and Nabor choosing not to object. As such, the fact pattern of C most clearly suggests an implied in fact contract. Let's look at question number 5. Park sued Officer Dinette for false arrest. Dinette's defense was that based on a description he heard over the police radio, he reasonably believed Park was an armed robber. Police radio dispatcher Brigg, reading from a note, had broadcast a description of an armed robber in which Dinette claims to have relied. The defendant offers the following items of evidence. 1. Dinette's testimony relating the description he heard. 2. Briggs' testimony relating the description he heard over the radio. And 3. The note containing the description Briggs testifies he read over the radio. Which of the following are admissible on the issue of what description Dinette heard? A. 1 and 2 only. B. 1 and 3 only. C. 2 and 3 only. Or D. 1, 2, and 3. Take 10 seconds. Choose the best answer. If you chose option D, all of the above, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is inadmissible because the declarant cannot be cross-examined when she speaks out of court and without cross-examination. One cannot tell if the declarant is lying or mistaken about the facts in their statement. Again, however, this is only an issue if the statement is being used to prove those facts that are true. As such, statements offered to show the effect on the listener and statements offered to show that the declarant knows the facts that are in the statement are not hearsay. In this case, while all of the items listed are out-of-court statements, none of them are being introduced to prove the truth of the matter asserted within them. These items of evidence are being introduced merely to show that the statements were made and or that Officer Dinette was aware of the facts in those statements. It is important to keep in mind that the action here is for false arrest, so the reasonableness of Officer Dinette's actions are at issue here. The items being introduced here are not to prove that Park was the armed robber or that the description of the armed robber was in fact correct, but rather only to prove that Dinette heard the description of the suspect on the police radio and his belief that Park was that subject in fact was reasonable based on having heard those descriptions. Question number 6. Smith joined a neighborhood gang at a gang meeting as part of the initiation process. The leader ordered Smith to kill Hardy, a member of a rival gang. Smith refused, saying he no longer wanted to be a part of the group. The leader, with the approval of the other members, told Smith that he had become too involved with the gang to quit, and they would kill him if he did not accomplish the murder of Hardy. The next day, Smith shot Hardy to death while Hardy was sitting on his motorcycle outside of a restaurant. Smith is charged with first-degree murder. First-degree murder is defined in the jurisdiction as the intentional premeditated killing of another. Second-degree murder is all other murder at common law. If Smith killed Hardy because of the threat to his own life, Smith should be found A. Not guilty because of the defense of duress. B. Not guilty because of the defense of necessity. C. Guilty of first-degree murder. Or D. Guilty of second-degree murder. Take 10 seconds and choose the best answer now. If you chose C, C would be the best answer. First-degree murder. First-degree murder is created by statute and typically consists of A. Intentional killing of a person, B. With time to reflect upon that killing, and C. Doing so in a cool and dispassionate manner. Duress is also not a defense to murder. In this case, first-degree murder is defined in the jurisdiction as the intentional premeditated killing of another. Smith is guilty of first-degree murder because she knew she was to commit this murder the day before it occurred, armed himself with a gun, went to the restaurant with the intent to kill Hardy, and actually, in fact, did kill Hardy. As such, Smith is guilty of the intentional premeditated murder of Hardy, being first degree. Question number 7. Happy Time Beverages agreed in writing with Fizzy Cola Company to serve for 3 years as a distributor in a 6-county area of Fizzy Cola, which contains a small amount of caffeine. Happy Time promised in the contract to promote in good faith the sale of Fizzy Cola in that area, but the contract said nothing about restrictions on the products that Happy Time could distribute. 6 months later, Happy Time agreed with Cool Cola Company to distribute its caffeine-free cola beverages in the same 6-county area. If Fizzy Cola Company sues Happy Time for breach of their distribution contract, which of the following facts, if established, would most strengthen Fizzy's case? A. Cool Cola's national advertising campaign disparages the Fizzy Cola product by saying you don't need caffeine and neither does your cola. B. Since Happy Time began to distribute Cool Cola, the sales of Fizzy Cola have dropped 3% in the 6-county area. C. Prior to signing the contract with Fizzy Cola Company, a representative of Happy Time said that the deal with Fizzy would be an exclusive. Or D. For many years in the soft drink industry, it has been uniform practice for distributors to handle only one brand of cola. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. For many years in the soft drink industry, it has been uniform practice for distributors to handle only one brand of cola. Contract interpretation is governed by 1. Course of performance, same people, same partially, but not completely performed contract. 2. Course of dealing, same people, different contracts. And 3. Custom and usage within an industry. In this case, the custom and usage fact established by answer choice D would most strengthen Fizzy's case against Happy Time. Question number 8. Perez sued Dawson for damages arising out of an automobile collision. At trial, Perez called Minter, an eyewitness to the collision. Perez expected Minter to testify that she had observed Dawson's automobile for 5 seconds prior to the collision and estimated Dawson's speed at the time of the collision to have been 50 miles an hour. Instead, Minter testified that she estimated Dawson's speed to have been 25 miles per hour. Without finally excusing Minter as a witness, Perez then called Wallingford, a police officer, to testify that Minter had told him during his investigation at the accident scene that Dawson was doing at least 50. Wallingford's testimony is A. Admissible as a present sense impression, B. Admissible to impeach Minter, C. Inadmissible because Perez may not impeach his own witness, or D. Inadmissible because it is hearsay not within any exception. Take 10 seconds and choose the best answer now. If you chose option B, you'd be correct. Admissible to impeach Minter. Under the Federal Rules of Evidence, any party, including the party calling that witness, may attack the credibility of this witness. Impeachment by prior inconsistent statement is evidence contradicting the testimony of the witness to undermine their credibility. However, prior inconsistent statements are not admissible to prove the truth of the statement because such statements would be hearsay for that purpose. Here, Perez calls Wallingford to impeach Minter's testimony that Dawson was going 25 miles per hour. Wallingford will testify that Minter had told Wallingford that Dawson was doing at least 50. Minter's out-of-court statement to Wallingford is not being offered to prove the truth of the matter asserted in that statement. Rather, it is being offered to prove that Minter may be currently lying or mistaken about Dawson going 25 miles per hour. Accordingly, Wallingford's testimony is admissible to impeach Minter. Question number 9. At the time of his death last week, Test owned Blackacre, a small farm. By his duly probated will drawn 5 years ago, Test did the following. 1. Devise Blackacre to Arthur for the life of Baker, then to Casper. 2. Gave all the rest, residue, and remainder of my estate, both real and personal, to my friend Fanny. At his death, Test was survived by Arthur, Casper, Sonny, who's Test's son and sole heir, and Fanny. Baker died a week before Test. Title to Blackacre is now in A. Arthur for life, remainder to Casper, B. Casper in fee simple, C. Sonny in fee simple, or D. Fanny in fee simple. Take 10 seconds. If you chose B, Casper in fee simple, you'd be correct. A pour autre vie, life estate, is measured by the life of someone other than the grantee. After the expiration of the preceding life estate, the fee simple will revert to the grantor, unless assigned to a third party. In this case, Tess's will devised Blackacre to Arthur for the life of Baker, then to Casper. At Test's death, this would create a pour autre vie life estate, and Arthur. Arthur's interest in Blackacre, however, expired at Baker's death, which occurred before Test's death. As such, at Test's death, the fee simple in Blackacre passed to Casper under the terms of this devise. And question number 10, the final question in this grouping. Arnold decided to destroy an old warehouse that he owned because the taxes on the structure exceeded the income that he could receive from it. He crept into the building in the middle of the night with a can of gasoline and a fuse and set the fuse timer for 30 minutes. He then left the building. The fuse failed to ignite, and the building was not harmed. Arson is defined in this jurisdiction as the intentional burning of any building or structure of another without the consent of the owner. Arnold believed, however, that burning one's own building was arson, having been so advised by his lawyer. Has Arnold committed attempted arson? A. Yes, because factual impossibility is no defense. B. Yes, because a mistake of law, even on the advice of an attorney, is no defense. C. No, because his mistake negated a necessary mental state. Or D. No, because even if his actions had every consequence he intended, they would not have constituted arson. Take 10 seconds and choose the best answer. If you chose option D, you'd be correct. No, because even if his actions had every consequence he intended, they would not have constituted arson. In order to prove attempt, the state must show that 1. The defendant intended to commit the crime, and that 2. The defendant took a substantial step towards completing the crime. Regardless of the underlying crime, attempt is always a specific intent crime. Legal impossibility is a defense to attempt. That is, if the person was attempting to do something that was actually not a crime, even though they thought it was, then they cannot be found guilty of attempt. In this case, the jurisdiction's definition of arson does not hold a person liable for burning his own property. So even if Arnold's attempt to burn his own warehouse was successful, it would not be arson in this jurisdiction. Arnold cannot be found guilty of attempted arson because of the legal impossibility. Therefore, Arnold has not committed attempted arson because even if his actions had every consequence he intended, they would not have constituted arson. Thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every morning at 8 a.m. Eastern Standard Time, and it is our goal to stay with you till you pass this exam. Don't forget to like, subscribe, and click that notification bell so you can be updated every time we upload new content.